for Tax Review Board hearings for May 22nd, 2025 are now in session. My name is Paula Weiss, Chair of the Tax Review Board. Joining me are John O'Connor and George Matthews, also members of the Tax Review Board. Today we are hearing licenses and inspections appeals. These hearings are being recorded and are part of the public record. There is no expectation of privacy for any participants today. These will be posted on our website following the conclusion of the hearings. So, Ms. Roach, you are here for case number 1, correct?
Yes, my client is petitioner Sean Cotman.
Thank you. So we do have petitioners in person in our hearing room for another case. We're going to hear that case first since they're in the room, and then we will have you join us as well. You're welcome.
Chairperson, if I may,
Yes.
Jeffrey Cohen, counsel for the City of Philadelphia. Part of the city's argument for Ms. Roach's case with Mr. Cotman is that the bill was not issued to Mr. Cotman. It was issued to the previous owner erroneously, so there is no liability at issue for Mr. Cotman.
So you're suggesting we start, I have some administrative matters to read into the record first, but if you're suggesting that you believe
I have a feeling
preliminary
that,
objection.
well, I have a feeling that Ms. Phyllis Spencer's matter with Mr. Levy is going to take some time, and I have a feeling the Cotman matter will take very little time, which we wouldn't have to keep Ms. Roach here the entire time.
Appreciate that.
All right, so maybe we'll do that. But in the meantime, or before we get on to then the cases where there are petitioners present to go forward, we do have some administrative matters to read into the record, and that is starting with what is listed as case number 4 on our docket. Last 4 digits of the docket, 90UM for Janine Winters. That matter has been continued. Case number 5 on our docket, Michael Reed for 1706 Latona Street. Last 4 digits of the docket, NZBN. That matter has been withdrawn. And case number 8 on our docket, last 4 digits, ABSJ. Yeah, Cathedral Village, 8500-10 Ridge Avenue. That matter has also been continued. So we are going to jump back up to what is listed as case number 1 on our docket, 1436 South Allison Street, Sean Cotman. Last 4 digits of the docket are ZDS5. Mr. Levy, we're going to ask you to be patient for a minute while we handle another matter before we get to your case.
Do you want me to mute myself or
I think,
video?
yeah, if you're going to have a conversation, you probably should mute yourself.
All right.
If you can. I don't know the hell that looks in there.
I'm going to put them in the waiting room.
Okay.
There
I mean,
you go.
that's fine.
Mr. Levy,
All right, so, pardon me, Milton?
Mr. Levy, turn the camera back on.
Hi.
All right, there we go.
All right, and he's
Go
muted.
ahead.
It's like,
Okay.
all right, so we're going to start with case number 1, Sean Cotman, 1436 Allison Street. We have counsel for the petitioner here. Ms. Roach, could you please state your full name for the record?
Yes, good afternoon, Madam Chair. My name is Mary Rose Roach. I'm counsel for Sean Cotman.
Thank you. All right, we're going to turn to Mr. Cohen first, I think, to start us off with any preliminary comments. Is it necessary at this point to read the numbers into the record?
I believe so. I mean, it is customary that we do so. So let's have
So
Ms.
who is your
Mitchell,
witness today for that purpose?
Ms. Lashika Mitchell.
Good afternoon, Ms. Mitchell. How are you today?
Good, how are you?
Good. Could you please state your full name and position with the city for the record?
Sure. Lashika Mitchell, I am the code administrator for license and inspection.
Thank you. Could you please read the dollar amounts and dates that are in controversy in this matter?
Sure. 1436 South Allison Street. This is a CSU demo bill, bill date 5/26/2020, bill number 212765, principal amount $13,963, admin charge $2,932.23. There's no interest. The total bill is $16,895.23.
All right, Mr. Cohen, opening remarks.
The bill that was attached to Ms. Roach's petition, or the petition that was filed by Mr. Cotman that Ms. Roach is representing him in. That also is the same bill that the city included in its packet. It was issued to Michael Anthony Knight, who was the previous owner. The city's packet also includes an OPA, Office of Property Assessment printout from around the same time, showing that even though the property had been sold, the OPA information had not been updated. So that explains why the bill was mistakenly sent to this other party. But as this board knows, if the bill was not sent to Mr. Cotman cannot be held liable,
And so
personally liable, I should say.
so the city is not pursuing Mr. Cotman over this bill? Are they pursuing the previous owner?
No, but
Hmm?
I will say, to properly represent my client's position, it should have been Mr. Knight's responsibility to file a petition to this board. That said, I think it would be absurd of the city to seek Mr. Knight's contribution for this particular bill. And the city also notes that this improvement happened, or the demolition happened sometime in, I want to say, early 2020, which means that we are rapidly approaching the 6-year statute of limitations on personal liability anyway.
Regardless of who might.
Yeah, regardless of
Right.
proper or improper
Maybe.
billing. So essentially,
Not
the
that
city is,
rapidly.
well, true, but if hypothetical, if the city were to issue today a bill to Mr. Cotman, and Mr. Cotman were to file an appeal to this board, then it would more than likely be scheduled for a hearing after the 6 years elapsed.
And this matter has been leaned on this property?
I believe so, yes.
Ms. Roach?
Yeah,
what would you
Mayor,
tell us?
yeah, so thank you, Madam Chair. My client purchased this property in May of 2019. The deed was recorded on June 7th, 2019. From the moment he purchased the property, the objective was to renovate it. There was he believes it could be attributed to a hack that happened around that time in 2020, 2019. And although he purchased the property, went through a title company, recorded the deed, and had these documents readily available, he was unable to do any renovations to the property because they had the previous owner, Michael Anthony Knight, listed as the property owner. And all notices were going to Michael Anthony Knight, so he was unaware that there was a demolition that was scheduled. He doesn't live in the city, so if it was posted, he wouldn't have seen that. So not only was he unable to renovate the property because of this issue with the city, not having him as the appropriate title holder, he never received any notice that a demolition was happening. He later found out from his contractor, who was unable to do work but was going by the property, that had gone by the property. I'm sorry, it was not the contractor, it was Anthony DiSabato. He works for the city, that the property was demolished. This was after the fact. It had been demolished. And because he was trying to obtain a make-safe permit, there was someone from the city that came by to inspect, and they said there was no property there. So that's how he learned of the demolition. Again, as Mr. Cohen has stated, he never received a bill, but there is now a lien on the property, which has further complicated his ability to do anything with it. So I think he's an innocent party here as far as like liability and what's transpired since he's purchased the property. It was beyond his control that this happened, and our argument is that he should not be liable for this invoice.
And I guess the city's position and Mr. Cohen.
Well, if we do end up addressing the merits, I do have a response with evidence showing that Mr. Cotman was given notice of the violations. But that's essentially immaterial for the purposes today, because if the city agrees that he is not personally liable, having not been issued a bill, then this should be a simple either dismissal for lack of jurisdiction or no action needed or some other resolution than addressing the merits.
So Ms. Roach, the city is agreeing on one portion of this, that your client is not responsible for the bill personally. we understand the property has been liened in this amount, which is another separate process. Our jurisdiction is limited to the billing and the in personam jurisdiction. The Municipal Liens Act does have a separate avenue through the Court of Common Pleas. So if the city is conceding there is no liability on the personal liability or in personam liability on the part of your client, there may not be anything for the tax review board to actually review. Does that make sense?
I understand.
Okay. Does the board, is there anything else you want to provide us with, Ms. Roach, though? We don't want to give you short shrift on this.
No, and I appreciate your time. I guess as you explained, the personal, not having personal liability, you're saying is there a separate proceeding for the lien?
There is, and that's through the Court of Common Pleas, and that's in the Municipal Liens Act itself lays out that appeal process, correct, Mr. Cohen?
Yes, and it's also in the city's position statement that I emailed to Ms. Roach and to the board.
Okay, so the documentation is there. I think that's where we stand. Board members want to step back for a minute?
Yes.
Okay, so Milton, we want to, everybody stay where you are. The board wants to have a brief conversation on privately. So Ms. Roach, just hang tight.
Mr. Cohen,
Yes.
I didn't receive an email. Which email address did you send it to?
One moment. I think the info address, I had to look it up online because I don't think there was an email attached. Well, because the petition was filed by Mr. Cotman, I checked out, I think, the entry of appearance, and I didn't see an email in that letter.
Okay, that's why I didn't get it, because I was a little confused when you were referencing things that I haven't received, but I know I can get them. They just go to my staff, so.
I'm sorry. I
No, it's
think I
fine.
sent it maybe earlier this week.
Okay, let me reach out to them just so I have that to reference, okay?
Of course.
Okay, I believe that everyone, we're back. Okay, Tax Review Board is back in session. We had a very brief conversation, obviously, but we did discuss where this matter stands procedurally. And it is our decision that in this matter, we don't believe we have jurisdiction to proceed, and we're going to mark it no action needed on our part. Can I get concurrence from board members?
Yes, John O'Connor, I concur.
George Matthews, I concur.
Always, I concur. So Ms. Roach, you are going to get a letter from the Tax Review Board in about 2 weeks with that decision that we concur that we cannot proceed with this. There will be appeal information in that for this decision to the Court of Common Pleas, but the Municipal Claims Act is a separate process that you can, choose to pursue in this matter. So I think that will conclude our business on this case for today.
Okay, thank you for your time today, everyone.
Thank you.
Take care.
Take care, Ms. Roach.
All right, we're going to move on to what is marked as cases 3, 6, and 7 for Selective Real Estate Group. We're going to put Mr. Levy back in the room.
They're on their way to unmute and turn the camera back on.
Okay. Okay. Mr. Levy, can you hear us?
Yes, ma'am.
Okay, so we're going to move on now to what is marked on our docket as Selective Real Estate Group, LLC. Those are cases 3, 6, and 7. For case number 3, last 4 digits of the docket are TA3C. Case number 6 is listed as C758 and case 7 is 703S.
Chairman, may I ask a question?
Surely,
Where are you getting that business name from?
I think that came from the petition.
If I may, I think it was listed on the petition as the alternate or company name. But
Is
I
there-
think the actual owner of the property is Ms. Phyllis Spencer.
We have that name as well, but I think that's what got picked up off the petition. Is Phyllis Spencer the correct petitioner name that we should be using?
Yes.
Okay,
And that's also the city's understanding.
okay. And the property, just so we're clear then, the property address is 450 North 60th Street. Is that correct?
Yes, Mr. Chairman.
Great. Okay. Mr. Levy, we're gonna have the city start us off reading the dollar amounts and dates and controversy, and then we'll turn to you to provide us with information and evidence that you want to present to the board.
As a preliminary matter, I have to repeat the city's objection from an email that I sent, I believe, with the exhibits. The city objects to the inclusion of numbers 6 and 7 on today's docket because they were added, literally the petitions and bills were added to the tax review board system 1 week ago. As it happens, through settlement discussions with Mr. Levy, I happened to bring these bills for the asbestos removal and asbestos monitoring to Mr. Levy's attention. So I knew about them, but in the ordinary course of business before this board, 1 week would be completely insufficient time for the city to prepare its case.
But you're prepared.
I would say my luck in being prepared for this should not have any bearing on the procedural matter that the city is bringing to the attention of the board. And with that, we can proceed with Ms. Mitchell's reading of the amounts.
We will note your objection for the record, and thank you. All right, so let's start with then case number 3.
Okay, 450 North 60th Street. This is the CSU demo bill date 2/21/2024, bill number 2023-013544. Principal amount $84,111. Admin charge $17,663.31. Interest is $5,429.68. There's also a lien fee of $106.45, bringing the total to $103,710.44.
And then case
se-
number 6.
450 North 60th Street. This is for the asbestos bill. This bill date is 2/28/2024. Bill number 23013765. Principal amount $9,255 even. Admin charge is $1,943.55. Interest is $560 even. Lien fee $106.45. Bringing that total to $11,865 even. Lastly, 450 North 60th Street. This is for additional work bill. This bill date is 12/23/2024. Bill number 24003425. Principal amount $8,350 even. Admin charge $1,753.50. Interest $454.68. Lien fee $106.45, bringing the total to $10,664.63.
Mr. Cohen, opening comments?
Yes, just briefly, what the city will show through the testimony of Tom Rybakowski of CSU, this was an emergency demolition. So there's essentially a subcategory of imminently dangerous properties where the city official believes that it is so emergent and so dangerous that the city has to start its demolition immediately, which is what happened here when part of the adjacent property's roof collapsed onto this property and caved in its roof, the property at 450's roof. Additionally, because this is a commercial property, there was asbestos monitoring as required under NESHAP, other environmental laws. And the monitoring found the presence of asbestos in a boiler in the basement, which is why there is an additional removal fee. So all told, there is a demolition, there is the asbestos monitoring, and then asbestos removal. And those three bills encapsulated the work that happened in, I think, starting in December of 2024 and going to, I want to roughly say January or early February of 2024. Sorry, December of 2023 to early 2024.
So the bill that was late, just so we have it on the record, the bill labeled additional work is actually a second asbestos-related bill.
The bill ending, 3425, which I believe corresponds to case number 7.
Yes.
That's the asbestos removal.
Okay, so
That's
I
the,
just want to be clear because I think Ms. Mitchell just labeled it additional work, but I want to.
yeah, I think if it's some additional add-on, they just label it additional work and just keep going. But that was specifically for asbestos removal during the demolition.
Okay, just so that's clear. Okay. Mr. Levy,
Yes, ma'am.
please go ahead and present your case.
I'm going to forego an opening statement at this time, if that's all right with you.
Okay, how would you like to proceed? The burden of proof rests with you and your clients. So
All right.
what are you looking for from the board?
What I'd like, all right, so maybe let me basically make an opening statement because I guess that'd be helpful. Our theory is this. This property had a vacant property license. So everybody knew, at least, that the property was intended to be vacant. If you go to phila.gov/LNI, you'll see that the official business address for this property is listed as 401 North 63rd Street, Philadelphia, PA 19151. If this was an emergency, and I want to point out that the city has been using that word for about a year and a half before they ripped the place down, I would believe that at some point they would have contacted Ms. Spencer at the official address rather than posting a notice on the 18th of December that 2 days later they were going to rip the place down. Our reaction was to send an engineer in there. And he is here to testify today that the place was safe. On the other hand, if the city really felt that there was an emergency, there are ways of approaching this through the legal process. In other words, there are obviously emergency injunctions that could be obtained, but the difference is the notice would have had to have been a process server going to 401 North 63rd Street, at least attempting to serve Mrs. Spencer with notice that she's about to lose a building and allowing her time to react to it. What I believe happened here was the conclusion was drawn the moment they walked in that because of the multi-story structure next to it that had to be ripped down, that they also wanted to rip down this place. We'll put on testimony to the effect that this place even is a one-story building that has incredibly most of its mass in the middle or back. So the idea is, even if this thing was to have fallen down, it would not likely have fallen into the sidewalk or anywhere else. It would have fallen in on itself. And yet, we'll basically present testimony today that with a couple of days' work, this place could have been made completely safe. And that's what they were undertaking. But 48 hours between the time you're told that they're going to rip your house down and the time it actually happens is not enough. Thank you.
Thank you. Well, then I'm going to ask you to go ahead and put on your witnesses.
All right. Mr. Davis, have a seat here.
How's everyone today?
Good. Could you
Good
please
afternoon.
state your name for the record?
Yes, my name is Matthew Davis, PE, structural engineer licensed in the state of Pennsylvania.
Mr. Davis,
Hold
thank
on, Mr. Levy. Mr. Davis, do you swear or affirm the testimony you're about to give in this matter will be the truth?
Yes.
Thank you. All right. Thank you, Mr. Levy. You can proceed.
Mr. Davis, are you familiar with 450 North 60th Street?
Yes, I am.
How are you familiar with it?
I'm familiar with it as Miss Spencer reached out to me to assist her in a few matters with the property. One, future plans, and two, to assist her with a violation she received.
Tell me, what sort of skills, what sort of licenses do you have with Pennsylvania or Philadelphia?
I'm a licensed professional engineer at the state level. I'm also a home improvement contractor statewide, and I'm registered as a special inspector with the city of Philadelphia.
What sort of education does that require?
It requires a undergraduate degree or bachelor's degree in civil engineering, and not necessarily a master degree, but I do have a master degree in structural engineering specifically.
Mr. Chairman, may I ask if Mr. Cohen would like to voir dire this man on his skills any further?
Mr. Cohen?
No, thank you. But
Do you accept this man? As
thank
an
you for the offer.
witness? Can we stipulate that this is an expert witness?
I will stipulate that he has the licenses and degrees that he has testified to currently.
After the 18th of December, 2024, did you have occasion to inspect the property?
Yes,
All right. Who asked you to do that?
Ms. Spencer.
Ms. Phyllis Spencer?
Yes,
And why did she ask you to look at the property?
because two things. She had some work she wanted to do for future plans, as well as she had to correct a condition that has come to her attention as of late, which is the roof condition.
The roof. And what plans did you, what conclusions did you draw after looking at the building?
After looking at the building, surveying the entire perimeter of the building, we found that roughly 10 to 15 feet of the front roof has fell in and needed to be, the rest of the structure roof needs to be shored, and this area needs to be repaired in addition to the side wall, which I would say is opposite of 4048 address property line, was leaning outward and needed to be demolished down to plumb level and rebuilt.
And did you have occasion to look at the rafters of the place or the things holding up the roof?
Yes,
Or were they still joined to the joists or whatever wall formation there was?
yes, for the most part, the entire structure, roof structure was intact, except the first 10 to 15 feet where the roof joist came out of the existing beam pocket.
Did that threaten the integrity of the walls?
Not necessarily. It was more of a condition that occurred at the end of the joist where it became attached to the exterior wall.
So in your opinion, was the place about to come down?
Not as far as the grand percentage of the structure. We're talking about a very small percentage, under 15% of the actual structure that actually needed addressing from a structural standpoint. The rest of the structure was sound.
All right. So the city has said the walls were bulging, I believe was the expression used in the report. Can you talk about that?
I would say wall. It's not plural because there was only one section of a wall, and even that wall is the only first 10 feet from the storefront, from the street sidewalk into the property lot that was actually out of plumb. Once you got past there and around the remainder of the perimeter of the property, all the rest of the remainder of the walls were plumb. Even the area that they complied on a previous permit years back. I think it was 2019.
You heard Mr. Cohen say in his opening statement that the place was in an emergency. Can you support that?
Not necessarily. I see that there's certain safeguards that needed to be put in place, which that's what my team was helping and assisting Ms. Spencer with getting done, so she can fulfill her obligation. I did not see that the majority of the structure or anything of that sort was in emergency condition at that time.
One of of the things in the city's report that I noticed was a statement, I guess, to the effect that, I'm sorry, there was, in the evidence somewhere, there is a statement that debris from an adjacent property struck 450. Do you know what to make of that?
I would say that I looked at when I did my assessment of her property, I observed in the city records that the neighboring property, which is roughly 3 stories, was already flagged and been on their system as imminently dangerous for a long period of time. When I observed the structure at the 1-story structure from Ms. Spencer, the exterior wall adjacent to her property from the neighboring structure was fairly sound in appearance, so it did not appear that anything from that structure may have fell and struck her roof.
Did you notice any marks of impact?
I couldn't make that out because of the debris and access problems.
Your witness, Mr. Goldberg. Cohen, I'm sorry.
Oh,
Thank you.
Sorry.
If I may, I'd like to share on my screen the city's exhibits that have been previously provided to the board and to petitioner's counsel.
yes.
Good afternoon, Mr. Davis. Can you see the exhibits packet that's on my screen?
Yes.
So I'm going to scroll down in the packet to the first exhibit, and this is an offer of proof. I will have Supervisor Rebikowski authenticate these photos.
Can you give us the
but-
page numbers, Mr. Cohen, so we can?
Oh, sorry, this is currently page number 3. So Mr. Davis, do you see in this photograph 450 North 60th Street around the same time that you inspected it?
Correct.
When did you inspect? Was it also December 18th?
It was the 19th. Yes, the 19th, the next day, not the 18th.
And then by the next day, was this brick debris that you see on the sidewalk still there, or was it taken away?
I do not recall that.
But do you recall seeing, and I'll move to page 4 here, do you recall seeing this part of the brick wall where bricks had obviously fallen out of the front part of this wall?
Correct.
And did you also remember seeing that the front wall here was disconnecting, and I'm going to zoom in a little bit, disconnecting from the sidewall, disconnecting from the front wall?
This condition in this photo is after they started demolition.
So what you're saying that on the 19th that this wasn't the condition of the property,
Correct.
even though this photograph is dated December 18th?
That property wasn't that in disarray.
So when you were there, was the demolition already started?
Correct. I was there
S-
2 days. The first day was 19th, second day was the 20th.
Mr. Cohen, if I could interrupt, what day did demolition begin?
I believe, and I'll have Supervisor Rebikowski testify to this, I believe the 19th, but I will, again, because I'm not fully certain myself, and I can get the word from the horse's mouth.
Okay, but this photo is actually dated the 18th.
That's correct.
Okay, go ahead.
So then were you there, when you were there on the 19th, did you see this curvature in the sidewall?
Yes, the wall condition was there and prevalent. There were a few more joists in place bracing that wall, but yes, this was the wall condition, and this is what we prepared a sidewalk closure letter for to get that permit for our client to close this off. That way they can restrict asset access and start the repair process.
And was this also what you in your report said, this particular wall, the one that needed to be demolished to plumb and rebuilt?
Correct.
Does that mean to plumb, meaning bring it all the way down?
To where the wall falls in plumb tolerance, which is by the brick, the BIA specifies plumb tolerance for brick masonry walls. So once we get down to where the wall is within a 1/4 inch plumb from vertical, that's when the wall can actually be reconstructed in brick masonry.
Kurt, I think we might need that in less
I
technical
was going to
language.
ask.
I'm sorry.
Board.
Yes, the wall could be rebuilt back to its original height and joists reattached to the wall.
And you said joists reattached. So in the meantime, there would be joists in the roof that would be basically unsupported unless some sort of support structure were built in its place.
My report specifies shoring, temporary shoring, and front bracing for the front wall, as well as sidewalk closure so that we can restrict access so this work can be carried out.
But I don't know if that quite answered the question, but would there need to be some other kind of structure put in place to hold up the roof joists while this wall was being torn down and rebuilt?
Yes, temporary shoring.
And how long would that take?
To put up temporary shoring, probably what, 2-4 hours?
And then to rebuild the wall, take it down, build it back up,
2-3 days.
and then rebuild the entire structure? Or
Not
the
entirely.
rest of the roof structure?
The roof structure that collapsed, probably a week.
So basically, we're not talking immediate. We're talking maybe like week and a half.
All the deterioration and defects that we observed could have been addressed within a 2-week time frame.
But in the meantime, would this wall have potentially posed a risk to the neighboring properties at, I think it was 448 North 60th?
448 is the one that is 3 stories that was already flagged as.
Oh, sorry. Then I mean the
So-
other, so the right side.
So for the right side, there's a easement that's owned by Ms. Spencer. Then there's a fence. Then there's a side yard space. Then there's a trailer on the right side of this.
And
So
behind that trailer, is there a playground?
behind that trailer, there's a play set in a private fenced area.
And are you aware of whether children actively used that playground around the time of this, around the time of December 18th of 2023?
I don't think anyone has their children out at that time of the year, especially at a playground, especially in freezing temperatures. So at that time, it did not seem adamant that that playground was active. Swing sets were wet. You know, it was cold. Yeah, nothing was going on there.
But you could understand if the city reasonably determined that there was a risk to the next door property and that the next door property did have children because that was its use. Is that correct?
It was a private playground, as in you had to have key access.
So that somehow makes it okay to put children at risk?
Objection.
I think we're gonna move on from this.
Okay.
We all recognize that
Okay.
children play outside in all kinds of temperatures and weather, and that's always a concern.
Well, in that case, I'd like to move on to page 6 in the packet. So you were saying that you said that only about, what, 15% of the roofing structure had been damaged. But if you look through the front window in this picture, do you see any roofing structure when looking through the window?
Yeah, as you see the black, that's the roof membrane.
The part of the membrane that fell into,
Yeah, into the structure, but this front wall is also still standing stout, so none of this protruded onto the public right of way.
but you also see back there, is that a chimney?
Yeah, it's plumb. It's mentioned in my report.
And
I'm sorry, I need to get a better understanding of what does it mean that it's plumb?
It's vertical. It's vertical. It's standing stout. So it's not leaning to the left, not leaning to the right. It's standing firm and straight vertically. Once you get out of plumb, that's when it starts to lean to the left, lean to the right. Code defines a tolerance for how far it could lean to the left or to the right, or even if it had a belly in it. And the chimney structure was sound at our time on site, and the first 10-15 feet of the wall that was previously shown was what we designated as needing to be partially demolished and rebuilt.
And where is
So
this
this-
hole that we're looking at?
Sorry, what was that?
Where is this hole that we're
Oh,
looking
sorry.
through the building? I'm
For
not,
context, this is the front of the property. And you can
yes.
see this orange ID poster that's stuck to the left of the door frame.
Mm-hmm.
Going down to page 6. Oh, I guess you can't see the left of the door frame, but this is the window that's to the left of that ID poster. You can see the door frame here at the
Oh.
right of this photo.
Thank you. Okay, just for some context here.
Mr. Davis, so did you take into account when writing your report the possibility of a cascade where the front of that brick wall falls and takes out of plumb the remainder of the wall, including that chimney?
We put together a sidewalk closure permit. That way the sidewalk can be closed and fenced off.
But the sidewalk is out here in front. If that chimney were to fall over, it'd fall into the next door yard, right?
The chimney is plumb per my report.
But that's not the question that I was asking. If the chimney were to fall, it wouldn't fall towards the sidewalk. It would fall towards the adjacent property to the right, correct?
The chimney is plumb per my report.
Okay,
Therefore,
Mr. Cullen, I
there's
think we
no-
Okay,
have,
I'll move
I
on.
think we have the answer.
All right. I have no further questions for Mr. Davis at this time. Let me stop sharing my screen.
Thank you. All right, Mr. Levy?
Ms. Spencer, would you take a step up with this? Thank you.
Good afternoon.
Good afternoon. Could you state your full name for the record, please?
My name is Phyllis Spencer.
Ms. Spencer, do you swear or affirm the testimony you're about to give in this matter will be the truth?
The truth, yes, I do.
Thank you. Mr. Levy?
Ms. Spencer, you own the property in question, 450 North 60th Street, is that correct?
Yes,
All right. Now, were you aware of L&I notices that dated back to 2017, 2018?
yes.
All right. And did any of those say that the building had to be taken down?
It had the same sticker that they placed this time, similar sticker, I should say.
When you got,
I'm sorry, is that a yes or a no?
Yes,
but when you got the notice, let's say, in 2018, that the place was imminently dangerous, what steps did you take?
Wait, I'm
I-
going to object to relevance. Why are we talking about 2018 when
I'm
we're talking
sorry.
with?
All right, so
Yeah.
when was the first you heard that this place was dangerous? When did the city first let you know that it was being torn down?
well, I received a notice, I've received a phone call on Friday the 16th.
From who?
The person on the phone said they were an inspector. I made a mistake, I didn't write his name down. But I asked what happened. He said, we had a storm the same week, a slight storm that week, which was December 16th, 2023. And he said to me, I'm going to take your building
We
down.
were talking about 2024, is that right?
No, we're talking 23. This happened in 23. They took my building down December 20th, 1923.
2023.
2023, yes. I said, what happened? He said to me, I'm gonna take your building down. I said, why? I said, I've complied with everything that the city of Epping asked me to do. I am not in any violation. He said, yes, because your bricks are falling from your building and there are some red bricks. I said to him, I don't have red bricks. If you notice my building have a light color brick and red bricks would be my neighbor, which is on the right side, and they have no building there. They have like a trailer. He said, well, they have kids playing in the back. I said, I don't think so. They had a daycare there about 5 years ago, and they don't have that daycare license anymore. There are no kids playing there. He said, well, I'm taking it down. I didn't hear from him again, so I got panicked. So I called the contractor who did all the work in 2020, in 19. I said, could you run over here and see what happened? Because I don't know what happened. The inspector just called me and said they're gonna take my building down, and I complied with everything that they asked me to do. He went over there, and it was the bricks from my next door neighbor. You know, when you take a building down, they leave a portion of their property. The bricks that were falling was the piece that they left, which could be fixed. So I called him back. I said, could you give me a little time? He said, no. I said, but in 2019, 18 to 19, you told me the same thing now, and you gave me 60 days and I complied. The inspectors were out. I bought 70 piece of LV beams, which cost $135 each. That's what the engineer recommended that I put in the ceiling. I put a new roof on the building in 2019. So the building was pretty much secured, and it has all iron beam framed around it. It's not a regular building that, you know, not well built. I said, can't I get a little more time? He said, no. So I contacted an attorney to see if they could help me. The attorney called on Monday and they said, you don't have any time. We took the building already. I've been taking pictures of pictures, asking my contractor who's here right now to take pictures for me. Let me keep a backup of what is going on. Monday, my building front started to be taken down. I have over $38,000 worth of material, new windows, 22 rubber roof that I bought, 6 kil of rubber roof. Somebody imported it from Iraq for me, and I have them stored in there. And they didn't even allow me to take one of my ladders. I had ladders, scaffold, all kind of stuff in there. Everything. The contractor went to retrieve some stuff. They told him that he was not allowed to go in there. But yet still their contractor loaded up his truck with all my rubber roof, taking them away. I have pictures of it. I think my building was taken down unfairly, because why would the next door building was tagged over 6 months ago. They did nothing to it. And in 2 days, just for our opening of about 10%, my engineer testified for, they wouldn't allow me to fix. And there was no children playing back there. That's not true. Because 15 feet of the building in the rear belonged to me. And the driveway lead to Gerard Avenue belonged to me, which my next door neighbor are using. So what you're saying about kids playing in the back, it's incorrect.
Mr. Spencer, what's the last time you were inside that place?
I go there very often, maybe every couple of weeks, because my office is right around the corner.
Before it was ripped down, were you able to walk through the entire place?
Yes, most of the time.
Was there any place that was dangerous to stand?
No, my building is made. The building is 5,060 square feet. Building A and building B. I have no problem with building A because it has the new work, and I have bills here to show that I spent $40,000 to repair everything in 2019. The building has solid concrete floor, except for the front is 12 by 12 basement.
How did you let the place get in that condition?
Well, because there, again, I had a pilot house in the rear in 2018, and that fell down when we had a heavy rain. So I got all the permits and everything from the city and did what they told me to do. And I had a different engineer. Mr. Henry was the engineer on record at that time, very well be known by the city. Trevor Henry. He did all the drawings and everything, and I complied, and the city sent out their inspector, and they inspected, and they said everything was done properly. And I had a clear bill on the property. No more problem until I get that phone call that day. And on the 22nd, they sent me a register letter saying, we are going to take your building down, but I have until the 28th to get a permit to fix it. The 22nd, I got that, but they'll take my building down on the 20th.
And the letter said that you had until the 28th to remedy?
I said I have until the 28th to get a permit. I have the letter here
A permit to do what?
to permit to fix the building, but they already take my building down.
That was the only thing that they sent to you at 401 North
Yes.
63rd Street?
Yes, and I have it right here.
So the only thing you received from the city at your official business mailing address for 450 North 60th Street was a letter advising you that there was a problem and you had how many days to fix it?
They said I can apply, I have until the 28th
Of December.
28th of December to get a
2023.
2023 to get a permit to do the repairs.
Your witness.
I went to the city to.
Okay. Thank you. We're going to turn to Mr. Cohen.
I was
Ross?
going to say, if she wants to complete what she was saying, I think she should be able to
Okay.
do that before
All
I
right.
start question.
I went to the city before the 28th to get the permit and I applied for the permit. And my engineer can attest to that. When I went to get the permit, they told us to come back the following day, but the building was 3/4 down on the ground already.
Okay, thank you.
And I spent so much to fix that building. And even if you look at the front of the building, you can see that I put stone front at the bottom. I just put new windows onto the right. The windows was like $4,000 and the stone front. The building was so solid. And all my materials that I have to see that their contractors took it all for himself. It's unfair.
Mr. Cohen?
Thank you. So I actually would like to share on my screen an email exchange. Good afternoon, Ms. Spencer. Do you remember receiving an email on December 18th in the early afternoon from Tom Rebekowski of L&I?
To be honest, I don't remember getting any email because I'm not too good with that. I always wait till the children come to help me.
Well, and I am asking about something that happened over a year ago. Well, does this email that's on screen appear to be an email from Tom Rebekowski to you at selective401@gmail.com?
Well, it appears to be that, yes. But
And this was a couple of days after you said you were called on December 16th?
yes, at 1:16 p.m. I got a call and the person identified that they were an inspector. That's why I said I'd forgotten to take his name.
Well, so you remember the specific time and date of the call?
Yes.
But don't remember the specific time and date of this email?
No, I don't, sir.
Do you remember whether you responded to this email?
I could have, I didn't remember. I normally wait until my children, mostly my daughter or my son, which is here, I always ask to help me because.
Well, who's your son?
My son is sitting right here, Desmond.
Oh, okay. Sorry, he's off screen, so I didn't see.
Yes, well, he's right here. And I generally wait until the kids come and say, check this for me and tell me what is it. And then they're trying to help me to get on it, but I'm not there yet.
Do you recall responding later that evening to Mr. Rebekowski saying, the structural engineer is away until the 6th of January. Can I be granted a little more time?
Possible, because I used Mr. Trevor Henry. And Mr. Trevor Henry went overseas his brother got sick, so he went away. So when I called him, he said he wasn't able to help me. So somebody told me about this other gentleman here, Mr. Davis. So I got him. But my regular engineer was out of the country.
But you do remember also asking, I have things stored inside the building, and I'm not in the best of health, implying that you would need to go and have someone come and get some things from inside the building?
Yes.
Do you remember?
No, it's coming back to me, sir.
Do you remember the response the next morning at 7:19 a.m.? I'll give your contact number to the contractor so that arrangements can be made to have the items removed. Do you remember being told this?
No, sir.
And are you aware that it's...
Where is this coming from? Are we supposed to be looking at email that confirms this or?
Oh, can you see the email that's on the screen?
Okay, yes, I wasn't.
Oh, okay, sorry.
Okay, so you-
I'm reading verbatim from the first sentence.
thank you.
This from Thomas Rebekowski to Ms. Spencer. And Ms. Spencer, are you aware of the general policy that when L&I does one of these demolitions, if there are personal items inside, that the contractor will store these items for, I believe, up to 30
I'm going to
days?
object to that.
No, sir, I have no
Wait a
knowledge
second,
of
wait a
that.
second. I'm going to object to that because how would Spencer know that particular L&I policy? She could only speculate.
Well, was she aware that L&I did inform her that the contractor could make arrangements with her to remove these items?
She answered that no. She did
No.
not
Okay,
recall
yeah,
that.
so I guess, Mr. Cullen, we're gonna move on. I think the question is, do you recall?
No,
the
I don't
email?
recall that, sir.
Do you also recall being told that you could obtain a court order to stay demolition from the Court of Common Pleas?
Yes, sir. I was told that on the phone, the first phone call.
And was that the attorney that you contacted?
No, I contacted attorney, his name, may I ask my son?
Oh, no, sorry, I meant was
His
that
name.
why you contacted the attorney?
Yes, I was going to try to see if they could file, as he told me, to save the property, but when I contacted the attorney, I even paid a down payment. They called me back and said they spoke to the L&I, and L&I said the building is already down.
Okay.
So
Okay,
the
Mr.
attorney,
Go ahead.
yes.
Are
Sorry.
you using these to confirm notice?
I don't
s-
remember them telling me.
Hold on,
about-
Mr. Spencer. Mr.
Sorry,
Cullen.
what
Are you
notice of
using these
what?
emails to confirm notice?
Confirm notice and also to show that she was informed the morning of the 19th, which was also the day that the city demolition permit was issued, that she could go to an attorney and go essentially on an emergency motion to get a court order, but that nothing was filed.
Okay,
I
okay, I
did
think we
not-
got that.
Okay, so
I
I'll move
wasn't
on.
aware of this one, sir.
Okay, so I think you can move on.
Yeah. I
Right,
was not aware of that, sir. I would not said I would be if I did. I
Okay, Ms. Spencer.
was not
Okay.
aware of it.
Mr. Cohen?
Ms. Davis, do you own other properties in the city of Philadelphia?
Spencer.
So I apologize, you're right, Ms. Spencer, not
Yes,
Mr.
sir.
Davis.
Yes, sir.
And those properties were, I believe, on January 17th of 2024, transferred into trusts for your children. Is that correct?
Yes, for not my children, sir, for two of my kids.
Oh, sorry, to your son and your daughter?
Yes, sir. I have 4 children, so just 2 of them because my eyes are a little blurry and they're the one who helps me with my emails and stuff. So they will manage few things for me that are better than I can do right now.
And
With keeping
forgive me for trying to summarize the relevant parts of the trusts that are in these deeds, but is it true that for the remainder of your life estate, remainder of your natural life, you maintain the power to receive profits and rents from these properties and to potentially dispose of or sell these properties?
This question, I'd like to know what the basis for this question is.
As Mr. Levy put in his response to the city's position statement, he claims that Ms. Spencer is indigent or does not have sufficient assets or resources. In direct contradiction to this, the city has and will show evidence that she does have massive resources in the form of these real estate assets that she moved into trusts about a month after the demolition had occurred or had started.
Okay.
If you'll permit me, just one moment, I'm going to share on my screen the exhibits packet that has been previously shared with the parties and the board.
Yeah, I think we're, Mr. Cohen, we could move on to the actual demolition
Okay.
process and the bills generated from them.
Oh, actually, yeah, sorry, then I will actually still share the city's exhibits packet.
Okay.
Sorry, but I'll move on to something different. So I'm going to go to page 30 in the packet. One moment. Just for the record, any highlighting that are in the city's exhibits are not in the original. They've been added for emphasis.
Okay, and we're gonna need you to zoom in a little bit if you can.
Of course. Is that better?
Yes.
Sure.
So Ms. Spencer, is this the abatement work invoice that you received for the demolition at 415 North 60th Street?
Yes, sir.
And did you receive it at 401 North 63rd Street?
Yes, sir.
And is this the petition for appeal that you filed to this board from this demolition bill?
Yes,
And that was dated, one moment, February 29th, 2024?
correct.
Fairly prompt, I think, within how many days? From the 21st to the 29th is 8 days, correct?
I don't remember, but shortly after I received it, I did it. So I was well within the time limit that I was given.
Oh, absolutely,
Yeah.
for this petition.
Yes, sir.
If you'll excuse me, I'm going to jump now to page 61 in the packet. Is this bill, the description of this bill is asbestos monitoring, correct?
Yes,
And was also sent to 401 North 63rd, that same address?
yes,
And the invoice date, February 28th, that's the day before you dated your petition, correct?
not sure.
But you did not file a petition for appeal from this until recently, I think May 15th of this year, correct?
That's incorrect.
So when is your petition dated from this bill, the asbestos monitoring bill?
I would have to look it up, sir. But I know it was shortly after I received it.
Let me ask then the tax review board if you could take notice of when petition number VLC7S8 was filed
All right,
from
speaking
the
Mr.
asbestos monitoring bill.
Thank Mr. Oates, Milton. Milton.
Yes, I'm looking for it now.
Okay, thank you.
And actually, I'm going to move on while Mr. Oates is looking for the tax review board's records.
I don't have that petition in front of me specifically.
I believe that would be May 15th, 2025.
And Ms. Spencer,
Okay.
this bill that I have on screen, would you agree this is for the description of work is for asbestos removal?
Yes, yes,
Was this also sent to 401 North 63rd Street?
yes,
The date of this bill is December 23rd, 2024.
yes.
If I could actually ask Mr. Oates to read into the record, what was the date the petition was filed for case ending WE703S?
And that would be also May 15th, 2025.
No, I didn't file it that time. I filed them both in a timely manner. I'll
Do you
see.
have copies
Yes,
of
ma'am.
the earlier petitions?
Yes.
Well, let me scroll
Okay,
down
I'll
then
just get my
to,
What though? One more.
this is page 70 in the city's packet. Is this the petition you filed from the asbestos
The last
removal bill?
one, yes, sir. I received it one day. I received that one day before I filed it. I think I filed mine on the 3rd, if I remember, January 3rd, I think, and I got it January 2nd, sir. I didn't get the bill for the asbestos until 2025.
But the
Mr. Cohen.
petition, I would point out to the board, the petition here says structural demolition. And page 70 is virtually identical to, we go to page 32, this petition.
Yes.
We'll take
I-
notice. Mr. Cohen, you can move on.
Okay, thank you.
Yes, that is incorrect, sir. I got it January 25, and I filed it January 25.
I'm going to stop sharing on my screen.
A year,
Um,
almost a year later.
Ms. Spencer, are you aware of the owner of the property to the left, 448 North 60th Street?
Yes. Mhm.
That's Mr. Kevin Wright, correct?
Yes, sir.
Now, have you attempted to file any lawsuit against Mr. Kevin Wright for either trespass or some sort of damage that his property did to your property?
No, I did not.
I think the board can take notice that Kevin Wright was actually, or had a hearing before this board in March for 442 North 60th Street, which is actually 2 doors down from 450 North 60th Street. But I'll have
We'll
Tom
take your
Rudakowski, the
word
city's
for it,
witness, get
Mr.
into
Cohen.
that. Okay,
We can, yes, we can take notice and check our records.
thank you.
move
Thank
on
you
to
very
the
much, Ms. Spencer. I don't have anything
Building
further for Ms. Spencer at this time, but if Mr. Levy wants to redirect.
But could I just say one thing before you go, sir?
I have a couple of redirects.
Oh, okay.
Just want to just make it clear for the record. The Rybakowski email, you remember getting that on December 19th of 23?
I remember an email, but to be honest, I don't remember the date I got it. Because that's why I haven't mentioned his name, because I said I forgot the name of the person who called me.
And that email came the same day as the demolition.
It might have been, but I was so upset that I really don't remember the
Thank you.
email.
Nothing further.
And I did not respond to it, so you can see that I didn't know that I have gotten it. But
Thank you.
I just wanted to say one
Is there
thing.
anything else you'd like to tell the board?
Yes, I'd like to say this, please.
Yes,
I have in my eye, they had sent me the 2 bill, and I was talking to Ellen and I about it. I did not get the 3rd bill until January of 25. Almost a year later. If you look and I have a Billy will show you, they filed a lien against me, and I had the title report, pull up a title report against me. And the only thing they had filed in 24 was for the $101 and for the $11.35. Then they didn't file anything again. And I'm working on trying to sell the lot. And in 25, they sent me another bill for $10,000 again. Why would they wait a year to send me another bill?
okay, we'll take that into account, that what you're saying is you did not receive that 3rd bill.
January, I received it, January
Until 2025.
25, yes, ma'am.
Um,
I filed it immediately.
okay. Mr. Levy, any other information or evidence?
Just a couple more contractor questions for Mr. Adams, who's at the site. And with that, tell the board your name
Yes,
My name is Dean Adams.
and what do you do
I'm a licensed contractor.
in the city of Philadelphia?
Yes,
Mr. Adams, do you swear or affirm the testimony you're about to give in this matter will be the truth?
yes, I do.
Thank you. Mr. Levy?
You've had the benefit of hearing a lot of testimony so far. What can you tell the board about 450 North 60th Street that's relevant to the demolition or the notice that Ms. Spencer got or didn't get, or the condition of the building when they gave notice?
In my years of doing contract, I'm confused why this whole building was demolished. I'm still confused because this building was past everything in 2019. Okay. Couple of years later, I don't understand how a building can deteriorate that bad in such small space of time that you have to demolish a whole building. Another thing, usually, if there's a problem with your building, you're given time to justify whatever the problem is.
Okay, so I'm
Shouldn't
going to
give no
stop you,
time.
Mr. Adams. This is argument, Mr. Levy. If
Yes.
there's evidence that
I-
you'd like him
I-
to provide, that
Yes,
would be fine.
thank you. Did you, when you took a look at the building,
Yes,
did you have a general idea of what repairing it would cost? Or what would be involved in repairing the building?
well, the day after, I went around there, took pictures. It was 3 LVL beams that slipped out of the pocket. All you had to do, the damaged wall on the side, all you had to do, repair that, put those 3 beams back into the pocket and redo the roof.
What
That's
do you
all.
estimate that would cost?
Maybe time-wise, maybe about 10, 15 grand tops, because it's not a whole lot of time.
Thank you. Mr. Cohen?
Thank
Mr.
you.
Cohen?
So it's your testimony, having been to the property on, I think you said the day after, was that December 19th?
I don't remember the date, but the day after, I went around.
I guess the day after what?
Well, that's what I'm trying to figure out.
Right,
Was it
right.
the day after what was when you went to the property?
After they went around there, because Miss Phyllis gave me a call when she got the call, so I went around there the next day.
Was the building still standing?
Yes, it was.
It had not been ripped down?
Nope,
No demolition had been done?
nope. There was a lot of contractors out there who was taking estimates and stuff like that.
Have they begun work yet?
Nope.
Okay. My best guess, that would probably be somewhere between December 17th to December 19th, based on when Ms. Spencer was given notice. Does that sound about right?
Objection. We've already established that Ms. Spencer was given notice on the 19th.
Ms. Spencer
So-
testified she got a phone call on the 16th, so we're
Yeah,
gonna that.
that's what I'm referring to, Mr. Levy. The phone call on the 16th and the email on the 18th. So, Mr. Adams, does it sound about right? Would it be from December 17th to the 19th, sometime in that range?
It's somewhere around there, yeah.
Okay. And you said that all that needed to happen was just to put back the beams in their pockets?
Existing wall that was compromised, you rebuild that wall, put the LVL beams back in the pocket, because they wasn't even compromised, the LVL beams.
Okay, so you are saying that the wall on the right side of the property, the one that faced those trailers, that's what needed to be rebuilt?
Right, not even the
Okay.
entire wall either.
Okay, and in your experience, have you seen when there's a part of a collapse, part of a brick wall, can that cascade through the rest of the wall?
Say that again?
When part of a brick wall collapses, can that cascade through the rest of the wall, meaning it takes the rest of the wall or parts of the rest of the wall with it?
Yeah, I've seen that, but that's not what the case on her situation either. That was not the case.
Thank you very much, Mr. Adams. I have nothing further.
Thank you.
The petition rests.
Thank you, Mr. Levy. Mr. Cohen?
Thank you. The city would call CSU Supervisor Tom Rybakowski.
No, good afternoon, Mr. Rybakowski.
Good afternoon.
Could you please state your full name and position with the city?
Thomas Rybakowski, City of Philadelphia, License and Inspections Construction Compliance Supervisor.
Do you swear or affirm the testimony you're about to give in this matter will be the truth?
Yes.
Thank you. Mr. Cohen?
Thank you. Supervisor Rybakowski, could you please very briefly for the board tell them how long you've been with L&I and in what capacity?
I've been with the department since 2014. I've been a building inspector, certified plan review specialist, and now supervisor assigned to the same unit, which is contractual service or emergency response.
And do you have any specific education or degrees that assist you with your job?
I currently hold 8 certifications through the ICC or the International Code Council and the state of Pennsylvania or the Uniform Construction Code as a building inspector. One of those certifications is building code official, basically meaning I could be the chief code official for any municipality in the state of Pennsylvania.
And through the course of your duties and viewing the records of L&I, have you reviewed the records for and been to the property at 415 North 60th Street?
I have not been to the property,
Oh.
but I have reviewed the records.
And with that, I'm going to share on my screen that exhibits packet once again. And please forgive me, I'm going to start from the top.
I'm going to make an objection.
Yes.
Do I understand that this witness has never been to this property?
That is what he testified to.
And what does he testify? Is he going to testify as to the condition of the property?
The city will offer, as an offer of proof to the board, the photographs taken by the inspectors on site through the course of their duties, and we will call on Inspector Rybakowski's experience to help the board interpret what is in the photographs.
I object to this witness. He has never been to the property. He has no firsthand knowledge. He's never laid a hand on that brick. He's never set his eyes on the beams, the joist, the ceiling, the hull, anything. He cannot possibly have any relevant testimony.
Mr. Cohen, response?
I think that's a bit dramatic. I think Mr. Rybakowski's experience speaks for itself. And certainly as a supervisor with L&I, who is, excuse me, Mr. Levy, certainly as a supervisor of L&I who actually supervises the inspectors that do these inspections, he can bring his experience to bear to explain what's in the photographs, to explain L&I's procedures, to explain the procedures of the city's demolition contractors, and he can explain to the board what happened here.
He could, but as a best evidence objection, if L&I had any other employees employed that day, the one that went to the building is the best evidence, not the one that reviewed a picture of the building.
All right, Mr. Levy, we're going to note your objection for the record and consider it, but we're going to move on with Mr. Rybakowski.
In what respect is he going to basically testify as to what the picture showed or what the
As to the
condition of the building
records.
was?
As to the records that L&I has on which they base their demolition and billing process.
As a foundational matter, can we establish who made this record?
I can ask that of Supervisor Rybakowski.
Again, who was there at the premises, took the observations and made
Well,
this record?
Well, you
Well,
have to
for-
let Mr. Cohen go forward and we'll get to that, I'm sure.
I was about to propose, Mr. Levy, if you can save this for cross-examination, I'll try and put on the evidence and foundation that the city has, and then that can be probed on cross. But
Get a glass of water.
yeah, can we take a moment?
Yeah.
Thank you.
And Madam Chair, this is the court reporter. Would we all like to go off the record?
Yeah, we're going to go off the record for 2
Oh,
minutes.
5-minute recess?
Yes, so.
Absolutely. Okay, we're now
Okay.
going off the record. The time is 3:26 PM.
We're gonna come back at 3:30.
It's a demolition or.
He never sold the house.
Huh?
The property, they never sold. How did they just said?
One guy's gonna testify.
Okay. Are we ready to go back on the record?
I don't believe, where did the
We need
petitioner
the
go?
petitioner. They're gone from the Zoom, so we're not back on the record yet.
Are they on a laptop and did someone close the lid of the laptop?
No, they're not, actually. They're on a desktop in our office. I don't know where Milt.
Is there someone available who can check out the desktop and see what's going on?
I hope so, Mr. Cohen.
Okay.
I don't see Milton back yet.
And while we're waiting, would anyone happen to have Mr. Counselor Levy's first name?
Oh, Bart. Sorry.
Okay, thank you.
Hold on, let me call Milton.
Oh, here he is.
Ah, Milton, we need the petitioner back in the room. They're not here.
Okay. Here we go.
All
Okay,
right.
Mr. Levy, we're gonna go back on the record.
Okay, just give me one
Supervisor
moment.
Rybakowski, if you could turn your camera and unmute.
Okay. And we're now back on the record.
If you'll permit me, I was about to share my screen, or I think I had shared on my screen. Just give me one moment. Right. Apologize for the delay. All right, here we are on page 3 of the city's exhibits. Can everyone see what's on screen?
Yes.
Supervisor Rybakowski, this is city's exhibit C1. Who took the photographs that are in exhibit C1?
They were taken by the area inspector responding to the emergency call, Inspector Madres. His date and the case file, and the signature, are on the left-hand side of the photograph.
And that date was December 18th, 2023?
Correct.
And is this part of Mr. Madres's ordinary duties to record these photographs?
Yes.
And is this something that LNI keeps in the ordinary course of its business?
Yes.
So what, if anything, can you see in this photograph?
You can see that a collapse has occurred. You can see that material, brick debris has fallen onto the public walkway, the sidewalk, and other debris has fallen off the side bearing wall of this property. There is a fracture that has occurred on the front wall of the property as well.
And that, one moment, scrolling down to page 4, is this the fracture you're speaking of?
The fracture is evident between the front wall and the side wall. There is also a step, that's a straight fracture, but there's also a step fracture up at the top line, just to the left-hand side of the connection point between the front wall and the side bearing wall.
Is that this over here that I'm going over with my mouse?
Right where your cursor is.
So step fracture in the front wall, fracture between the front and side walls, is that correct?
Yes.
What is going on here with this sort of separation between the 2 layers of bricks in the sidewall?
That's where the 2 weights of bricks have separated and material had fallen on the public walkway and into the adjoining easement.
By material, do you mean bricks?
Yes.
Is it concerning that bricks are falling off of a wall?
Yes.
Why is it concerning?
Because debris, brick, the wall could hit an individual and could potentially lead to the death of that person.
Is there also a concern about a partial collapse of part of the wall destabilizing the remainder of the wall?
How far back? But yes, there is an area of concern of having a further collapse of that building.
And would this concern be heightened if the roof system that also attaches to that wall were compromised.
Yes,
And in fact, was the roof system attached to that sidewall compromised?
yes, it's in a state of collapse.
What's this in the front window here, the front right window?
That's the roofing members that, or the structural members of the roof that have collapsed.
So the things that used to be attached going left to right are now sort of fallen and collapsed into the interior.
Yes.
What effect does that have on the standing wall?
Depending upon how severe the collapse is, it can push the wall over because it's literally pushing the structural members out of the pockets and then could lead to the wall collapsing further.
Actually, that was going to be my next question, is the cause of this fracture. Could that be materials that are pressing outward on that right side wall?
When they fell or when they put, yes.
Now I'm scrolling down here to, excuse me, one moment, to page 5 in the packet. What, if anything, do you see on page 5?
It's another photograph taken of the property of the side bearing wall and the front wall by Inspector Madres on December 18th.
Now, what's this little speck here that's right in the middle between where the layers of brick have started separating?
It looks and appears to be the remnants of the roof rafter pocket where the roof joist or roof rafters would have been married into that masonry wall.
And scrolling down now to page 6 in the packet, what, if anything, do we see in this photo?
That's just a photograph of the front of the property illustrating the collapse of the roof.
So can we see straight through the front window to the sky behind it?
Yes.
And do you also see that chimney that's standing here that's on the right side wall?
I do.
What are L&I's potential, or what at the time were L&I's potential concerns with the state of this property?
The further concern was the material or more collapse of this building onto the public walkway and the side bearing wall collapsing further.
Was L&I aware of anything that had happened to the adjacent left side property, 448 North 60th Street?
We were aware of the properties being declared as unsafe or eminently dangerous.
Who owned the property at 448 North 60th?
Kevin Wright.
Were we here before the Tax Review Board in March with Mr. Wright for 442 North 60th?
We were in front of this board for an address that Mr. Wright owned on that block, yes.
Was that also for an unsafe or imminently dangerous property?
Yes.
And how many of Mr. Wright's properties on this block were unsafe or imminently dangerous?
I'm going to object to that question for relevance.
Okay, let me withdraw it and I'll focus in more specifically. Was 448 North 60th Street declared unsafe or imminently dangerous?
Yes.
And what, if anything, up until December 18th of 2023 had Mr. Wright done to address those conditions?
I'm not aware of any.
So what happened around December 16th to 18th of 2023?
The department placed those properties out to bid for demolition.
Including 448 North 60th?
Yes.
Did anything collapse at 448 North 60th around that same time?
Objection. Can I ask whether the inspector visited 448 or was this just from pictures?
Well, let me ask for foundation. Inspector or supervisor, did you review the records for all of these properties in preparation for today?
Yes.
And did you review the records specifically of Mr. Wright's properties back in March for preparation for that hearing?
Yes.
Mr. Cohen, I don't know that this is relevant to us.
Well, specifically, the relevant question here is, did anything collapse off of 448 onto the roof of 450?
That's it.
I don't know about onto the roof of 450, but I do know that we were called out to the property in response to material that had fallen off of 444 and 448 onto the public walkway as well.
Well, specifically 444 and 448, is that one building?
That's one parcel, yes.
Now moving on to page 7 in the packet. Is this a copy of the imminently dangerous poster that was placed on this property, 450?
It is.
And what does it say written down at the bottom here?
It has the demolish for public safety. It is placed on the property December 18th of 2023, and it has the initials of the inspector, Inspector Madres.
Sorry, where did Mr. Levy go?
I'm sorry.
Okay, sorry. No, that's okay. I just want to make sure you're here. Why did L&I believe that this property needed to be immediately demolished?
Because material was falling onto the public walkway, and we were, in the interest of public safety, more of the property could have fallen onto the walkway and lead to a further collapse.
Was L&I concerned about a sideways collapse of that right sidewall?
We were concerned about the adjoining property and if the wall could collapse into that adjoining property.
Did L&I at the time know of the use of the adjoining property?
No.
Did L&I at the time know that there was a playground further back behind the trailers at the right side property?
We knew that there was the potential of children being in the vicinity of this building, and that's what drove the emergency response.
Going now to page 8 in the packet, exhibit C2. What is this exhibit?
This is an email that I sent to Miss Spencer on December 18th following a phone call that I had with her the same day, telling her that in the interest of public safety, we were moving forward with an emergency demolition of the building at 450 North 60th Street.
And I showed Miss Spencer further emails in this chain. If I could just ask you, did she respond to this email later in the evening on Monday?
Yes, she responded to the email following my conversation.
And did you respond the next morning around 7:19 a.m.?
I did.
What, if
Let's
anything,
stop
did
you when
you?
you say responded? Was this phone conversations or is this email responses back and forth?
I had a phone conversation with Ms. Spencer, and I also had email communications as well.
Okay.
And in your email on the morning of December 19th, did you inform Ms. Spencer of that she could speak to the contractors about her personal belongings in this building?
I said I would relay her contact phone number to the contractors, and she could speak to the contractors about retrieving her personal effects from that building as long as they could be done safely.
And what is L&I's policy regarding retrieving personal belongings prior to a demolition?
It's the responsibility of the owner to provide or to retrieve their belongings from the building or from that facility.
And is there a policy for our L&I's demolition contractors for whether they should remove and store any personal belongings?
In some cases, the department will or the contractor will arrange to place those personal effects in storage for 30 days, and then the owner would take responsibility for those or for that payment of that storage.
Well, you said in some cases. Is that dependent on essentially how safe it is?
Yes.
And did you also inform Ms. Spencer on the morning of the 19th that she could file an emergency TRO or temporary restraining order action to stop the city's action?
I did.
Was any TRO filed?
No.
Well, I'll get to that in a second. Let me first put on screen what's on page 9, Exhibit C3. Supervisor, what is this document?
It's a violation notice in order to correct for the same case file, CF Charlie Frank 2023127069, mailed out to a Miss Phyllis Spencer, declaring the property at 450 North 60th Street as eminently dangerous. The date of the notice is December 19th of 2023.
And for these types of documents, does L&I keep them in the ordinary course of its business?
Yes.
And is the information that goes into this document entered by an inspector through their usual duties?
Yes.
Now, with respect to this document, does it contain boilerplate language about taking immediate corrective action?
It does.
And is that down here that you are ordered to make repairs prior to December 28th, 2023?
It does, yes.
And is that automatically put onto all notices of this type generated by LNI's electronic system?
Yes.
In this specific case with this specific property, did LNI deem it necessary to move forward with emergency action?
In response to my phone call with Ms. Spencer and my email, the department used an emergency action in response to this property and placed it to immediate demolition bid on the December 18th.
And does this notice contain here in highlighting the Department of Licenses and Inspections hereby certifies that the violation at this property creates a condition of immediate danger or hazard to health and safety and welfare?
Yeah.
Is that a written certification of the type that you were talking about earlier, justifying an emergency?
Being that the property was deemed as eminently dangerous and using that language, yes, it was an emergency action that the department pursued.
Scrolling down in this notice to page 12, do you see where it says you have the right to appeal this notice?
Yes.
Was this notice actually appealed to the board's
Yeah,
administration?
I'm going to object to that too.
Well, on what grounds?
My grounds are this, that notice you're looking at there that you have an exhibit has been superseded by an emergency order, which makes this void or moot. In other words, this document here gave her until the 28th to make the repairs. How do you justify tearing the place down the next day? She
Well-
she got off that phone and got off that email thinking, all right, now I got to spend the next week finding a contractor. What in this document we're looking at now gave the petitioner any idea that they were coming out the next day and to demolish the place? Was she ever sent
if I
another
could-
violation notice?
All right, Mr. Levy,
Changed her
if I
mind,
could-
they're
Calm
coming out
down.
tomorrow.
need to calm down and let Mr. Cohen respond.
If I could respond, Mr. Rebikowski's email, one moment. This email was sent out on Monday, the 18th. It said that the property is collapsed and in the interest of public safety, the department is moving forward with the demolition. So this would be the notice to Ms. Spencer that there was an emergent issue that LNI was immediately addressing.
Objection, where does it say
Hold on,
emergency?
Mr. Levy.
Hold on, Mr. Levy.
This document contains some boilerplate, including the order to make repairs, which is why I had Supervisor Rebikowski testify to that. With respect to the appeal language, I don't want to get too much into legal issues just on an objection, but
let's
as
get into
a matter of due process, a post-deprivation hearing opportunity was called for and was provided by this notice. And what I'm going to ask Supervisor Rebikowski following this is, was that post-deprivation opportunity actually taken advantage of, or was it a failure to exhaust an administrative remedy? So that's the relevance.
As a foundation, how is that post notice sent?
Well, I can ask that of Supervisor Rebikowski.
Okay, go on.
Supervisor Rebikowski, by what methods is this notice delivered once it's issued?
We sent the notification for first class mailing and also certified mail.
And was there any appeal filed to the board's administration from this notice?
Not that I'm aware of.
And I'm going to scroll down now to page 13. Is this essentially a duplicate copy of the same notice sent to a different address?
It is.
Where did that address come from?
Oh, sorry. Let me scroll back up. The address 1230 Remington Road, Wynwood, Pennsylvania. If you could please answer the chairwoman's question.
The department has a research team that will try to find additional addresses for responsible parties or individuals associated to properties throughout the city.
Again, I'm going to object on the basis of the fact that we've already established that the official mailing address for this address on the city records is 401 North 63rd Street.
Which
And
is where
it's also
this copy
on
of
one
the
of the
notice.
notices. You know what,
Yes.
Mr. Cullen, I think we probably have saturated the notice issue. Let's,
Of course. Let me move now to 17. Supervisor Rybakowski, what is this document that I have on screen?
It's a printout from the city's Atlas system showing the research for 450 North 60th Street, showing that the owner of record is Phyllis Spencer and the owner mailing address is 450 North 60th Street.
Were any appeals filed from any notices issued to this property?
No.
Is this a document that LNI keeps in the ordinary course of its business?
Yes.
And is the information that goes into this document entered by LNI employees through the ordinary course of their duties?
Actually, this is pulled from the Atlas system. So this is actually the Atlas system pulling all this information from the database that the department.
Well, then let me be more specific, because you're right. The information that goes into business licenses is pulled from different employees who do the permits, then the violations. Is the information pertaining to the appeals drawn specifically from the Eclipse system, and would that be entered by, say, an appellant filing an appeal?
Yes.
Okay. Now moving on to pages 18 through 20, and I know these are very small, and I will make them bigger. What are these documents on pages 18 through 20 that are Exhibit C5 in the city's packet?
They are the bids that the department received for the demolition of the property at 450 North 60th Street.
And were these bids taken on the date listed, December 18th, 2023 at 10:30-ish in the morning?
Roughly, yes.
Who submitted this bid for $84,111?
It appears the signature is Pacioli, which is the demolition.
Was that the contractor for this specific demolition?
That would be the one that was submitting the bid for this demolition, yes.
And was there another bid for $111,000?
Yes, from FH Demolition.
And another bid for $112,000?
Yes, from Palmer Construction.
So which of these contractors did the city go with?
We took the lowest bidder, which was the first bid shown in the packet.
And actually scrolling down to the next document on page 21, is this the demolition permit that was issued the next day as a result of awarding this bid?
Correct. The bid was awarded to Pacioli Construction Incorporated with the cost of $84,111, which was the winning bid.
And is this a document LNI keeps in the ordinary course of its business?
Yes.
And is the information that goes into this document entered by someone at LNI through the course of their duties?
Correct, yes.
All right, one moment. I'm going to scroll down to 24. I'll try and be brief, but there's a lot of documentation to go through. What is this that's on screen?
That is the purchase order from our procurement office. But basically, it's a proceed order made out to the winning bid contractor, which would be Pacioli.
And this PO or purchase order number at the top ending in 159, do you see that?
Yes.
Is that the same number that is on page 28 on this invoice?
It is.
And what is this document on page 28?
Page 28 is the invoice that the department received from Pacioli in response to the demolition of 450 North 60th Street.
And when did LNI receive this invoice?
The invoice was received on February 13th of 2024.
One moment. Scrolling down now to page 29. What is this document that's on screen?
I'm sorry, Mr. Cohen, can you scroll up just one more second? I was trying to make note of something here.
Yes.
And that, just note for the record, says complete demolition at 452 North 60th Street. That's the address we're talking here, right?
Supervisor, is that an incorrect address?
That is a typo. It is for the demolition at 450 North 60th Street.
Do you have
And
the
is that-
actual document then?
Is that why I pointed out the PO or purchase order number and matched it to the purchase order on page 24?
It is for the demolition and the invoice for 450 North 60th Street.
So Pacioli
Sorry, Mr. Levy, it was in anticipation of exactly the question that you asked. There is a typo on the invoice, but the purchase order number links directly to, and I'll go back to page 24.
There's actually
450
two typos on that
North.
page.
Well, yes, but the point that I am trying to make, Mr. Levy, is the number 84,111 and 450 North 60th Street that are linked to this purchase order number. Those, the total amount is the same, and they got one digit off on their invoice.
If it speeds things up, we'll stipulate that these are, perfectly reasonable amounts to do this work.
Thank you.
Thank you very much. All right, let's move on.
Let's just note, is this an approval by L&I on February 21st of the amount of demolition?
This is the final payout that the demolition was completed and that it is a final sign off on February 12th of 2024.
February 12th, or is it February 21st, according to the date up at the top?
It's dated on when that form was filled out, but then it was sent over on February 21st of 2024.
Is that also the date that the abatement work invoice on page 30 was issued? February 21st, 2024.
Yes.
And I offer this up as the invoice that was actually appealed on February 28th or 29th by Ms. Spencer. And that's for docket number SKTA3C.
Right.
Now moving on. Sorry. Oh, sorry. Up here on page 33 in the packet, what is this document?
That is the asbestos report because this is classified as a commercial property. So a asbestos monitoring is required. And this is the report that there was asbestos found in the basement of the property.
Specifically the boiler insulation?
Yes.
And who prepared this report? Or actually, one moment. Let me scroll down to the next exhibit.
Levy,
Starting on.
I'm going to interrupt you. Mr. Levy, do you have any objection to this report or challenge to it?
Nope.
Okay, then we can just accept it, Mr. Cohen. Move on.
Oh, okay. Thank you. I'm not going to go through all of these. That would be ridiculous.
Thank
I
you.
will point out for the record, pages 34 through 42 are a bunch of event logs. Supervisor Rybakowski, who wrote these events logs?
The asbestos monitoring employed by BATA, which is the inspection agency that was awarded this location.
And is that BATA Environmental Associates, Inc. up here at the top?
It is.
How does the city choose its asbestos monitoring contractors?
There's a rotating list that is assigned by our fiscal unit when it is required.
And was it required here for this property?
Because this property is classified as a commercial property, then yes, it is required for there to be an asbestos monitoring.
Mr. Cohen, Mr. Levy's not objecting.
Okay, then I'll just move on. Page 43.
Mr. Cohen, if I may
just-
say, I have no objection to any of the city's actions after the demolition. My objection is, of course, with the notice of the demolition. Everything that happened after that's normal business as far as I'm concerned.
Okay, well,
You picked up what you knocked down, right?
Well, why don't we, for the purposes of this direct, put a pin in the notice issue, and I'll just move through the rest of the exhibits as quickly as I can. Just to note for the board's records, pages 43 through 54 are a bunch of laboratory tests. Were these tests performed by the contractor BATA for the asbestos?
Yes.
All right, then we'll move to Page 55, was this a final report after the demolition put together by BATA?
Yes,
And finally, was on page 58, was this the invoice that BATA sent to L&I for the asbestos monitoring work?
it is.
And is this breakdown here that we see over here, was that approved by L&I and the total amount of $9,255 approved for this project?
It was.
And just for the record, was the date of this invoice February 27th, 2024?
It is.
All right, and what is this document on page 61 that I have on screen?
It's the invoice sent out to the owner of record for the asbestos on-site inspection abatement for the total of $11,198.55 for the principal and the administrator for the asbestos monitoring at that location.
And was this sent the day after L&I received the invoice from BATA?
It appears to be, yes.
And was it sent to the same address that the previous imminently dangerous notice and the previous demo bill were sent, 401 North 63rd?
Correct.
Moving on, hold on one moment. All right, page 66. How does L&I, when L&I does find asbestos on a city demolition site, how does L&I pick a contractor to remove the asbestos?
It's actually the demolition contractor that will find or locates the asbestos. The monitor sees the asbestos there, and then the contractor is responsible for employing the abatement company to abate the conditions.
And is that part of the city's usual contracts with its demolition contractors? When there's asbestos found, this is what you do?
Yes.
What's the date of this invoice?
This invoice is January 2nd of 2024.
And was it sent by the same contractor who did the demolition?
It was.
And does this one actually have the corrected parcel address?
It does.
What's the amount of this invoice?
This invoice is $8,350.
And when did L&I issue approval of that $8,350 amount?
December 23rd of 2024.
That seems like a fairly significant delay, correct?
It is.
Is there a reason for the delay?
We received the invoice from the contractor. The contractor, I don't have an answer.
But the date on this approval would be when L&I actually issued the payout?
They would be, yes.
And is that also the same date that this invoice was issued to Ms. Spencer on page 68 for the asbestos removal?
It is.
And is that $8,350 amount under here, labor, materials, and equipment on this bill?
It is, plus the 21% administrative fee, bringing the total to $10,103.50.
And was it sent to the same 401 North 63rd Street address?
It was.
Okay, I'm done with my questions for Supervisor Robakowski on direct. Mr. Levy, if you want, I can continue sharing my screen if you want to use the exhibits. Otherwise, I can stop sharing my screen.
I appreciate if you share your screen, but I don't know who's going to move the exhibits around if I need to.
I was going to say, tell me what page and I will take you there.
Mr. Chairman, can I have like 1 minute to talk with my client before I cross-examine Mr. Robakowski?
1 minute, Mr. Levy.
Thank you.
We're off the record.
Okay, we are now off the record. The time is 4:04 p.m.
Milton, while you're sitting there, I know after this completion, we have case number 2 that we have not dealt with. Is there anybody there?
No.
Okay.
And then probably the one person that we had on in the waiting room, they dropped off. So more likely we're gonna continue that one.
No, I saw the name and that was a case we had already dealt with their attorney, so they came late.
Oh, okay.
That was
Was
case
that Mr. Cotman?
Yeah, Mr.
in the
Cotman
lead?
showed
Okay.
up in the Zoom room, but that was not until after 2:30 and we'd already handled the case. So I'm sure that his attorney will speak with him.
Okay.
This case number 2.
I'd give them another minute and I'll bring them back in.
Yeah, please. All right, Milton, go find them. Or they're back. Okay. All right, Mr. Levy, you ready to proceed?
Yes, ma'am.
We are back on the
Um,
record. Mr. Cohen is going to share his screen. Hold on. Okay.
Already done.
Mr. Rabikowski, good afternoon.
Good afternoon.
You heard, were you here from Mr. Davis's testimony?
I was.
All right. Did you talk to Mr. Davis on the telephone at any point?
I did not.
You didn't talk to him on the 20th of December? He didn't call you to tell you that no one was working on the place?
No.
All right. Let me ask you this, the bidding contractors, that notice was sent, or you picked those contractors on December 18th, is that right?
Yes.
And when did they give you their bids?
The 18th.
All right. Did they visit the property?
On the 18th, yes.
How do you know that?
Because that's their sign-in sheet. So they are literally looking at the building and signing in that they are giving their bid for that property.
All right.
Good, page 18.
All right. So let's look at page 8.
8.
Exhibit 8, I guess.
Oh, sorry, is that page 25, exhibit 8?
Yeah, no, just Cities Exhibit 0008.
Oh, sorry, page 8, which
Right.
is Cities Exhibit 2. Sorry.
Was this it?
Right.
Okay.
So, what I'm going to ask you about is the second sentence in this email, the property has collapsed. What did you mean by that?
It suffered a collapse. The roof collapsed. And it's got a collapse of the side bearing wall.
So the place basically just crumbled to the ground? The whole place? Was it partially collapsed or was it collapsed?
It's collapsed.
Entirely?
Well, it suffered a collapse. Whether or not it's entirety or not, it still has a collapse.
You don't think that's worth clarifying in a letter to a layman, right?
I stated that the property suffered a collapse and that we were moving forward with an emergency demolition in the interest of public safety.
Now you communicated, I'm sorry, the petitioner got a call, I guess. I guess the story is the commissioner got a contact by telephone on the 16th. Is that right?
I know I spoke to the appellant today. I spoke to the appellant on the 18th via phone.
18th. And what did you tell her then?
I told her that the property, exactly the same as the email indicates, that the property suffered a collapse and we were moving forward with an emergency demolition on the 18th.
And did you ever send her anything contradicting the notice she got that she no longer had until the 28th to make repairs?
Sir, you're looking at it right now.
That is the notice?
That's the notice that we're moving forward with an emergency demolition.
And that is the only, let's just say, service of process, your notice that you were demolishing the house the next day was.
No, we placed it out the bid on the 18th.
When did you tell when did you tell Ms. Spencer that she could get a temporary restraining order?
On the 19th.
On
in
the-
response to her email back to me.
And the 19th, just for the record, was a Monday, right?
No, the 19th is a Tuesday.
Okay, the 19th was a Tuesday. And what time of day do you think you had that conversation or contact?
I don't see that email, but I'll be happy to tell you the time stamped on that email.
For the record, if we were to go back to Ms. Spencer's testimony, it was 7:29, or sorry, 7:19 a.m.
All right.
Should already be in the record.
And when did the demolition begin?
The demolition, after awarding the bid, the contractor can start a demolition within 2 hours of winning that bid. So they could have started it on Tuesday, the 18th. I mean, Monday, the 18th.
All right. So essentially, you advised her to get a restraining order a day after they began?
I advised her that if she wanted to stay the demolition, she could file with the court. And my response from the email was on the 19th.
And the demolition took place on the 19th, is that correct?
No, the demolition was awarded on the 18th. The contractor can start 2 hours after winning that bid.
I'm going to interrupt you, Mr. Levy. Mr. Bukowski, do you know when the contractor actually started? Which day?
No.
Okay. He could have started on the 18th, but we don't know.
Who knows?
Don't know.
Is there a record of it anywhere? Mr. Rabikowski, is there a record of when the demolition began anywhere?
There's a record on the 20th that the front wall had been removed from the property following an inspection from the area inspector.
So on the 18th, they could have begun demolition. On the 19th, you spoke and told her to do a restraining order. And on the 20th, it was a fait accompli. Is that right?
Well, he said part of it. He didn't say all of it.
I'm not sure of your question there, sir.
Was there enough to repair after the 19th?
Can you repeat your question?
Well, actually, I'm going to object. I'm going to object to that on the basis of the knowledge of this particular witness, especially because Mr. Levy, two of your witnesses were out there on the 19th, and they testified to observing the conditions on that date.
Right.
Well, Mr.
So
Cohen.
they would have better knowledge than
Mr.
Supervisor
Bukowski can
Bukowski.
simply say he doesn't have that information, and that'll.
The reason for the city's objection is he already said that, and Mr. Levy is asking the question again.
All right, so if you want to go asked and answered, that's fine.
Okay, asked and answered.
Okay.
So
And
in
we'll
your
move on.
advice to Ms. Spencer about restraining orders and her right to, let's say, stay what was going on, where did you get your experience with restraining orders?
I've testified in multiple filings to stay a city demolition.
Have you ever worked with an attorney to do a restraining order?
I don't see the relevance, Mr. Levy. He
I
didn't say.
want to know how long he thought it was going to take her to take the advice he gave her. So let
Well,
me
I
ask
think
you,
this is-
how long do you, in which when you told the lady she could get a restraining order, did you expect her to react instantly to that?
I'm not your client. I don't know.
I understand, but when you gave, let's say if you pictured a possible remedy of Miss Spencer getting a restraining order, did you really believe that?
That's not an answer for me. That would be for your client.
I'm asking you whether you believed a restraining order was possible on the 19th.
If she's filing it, then anything's possible. I don't know. I'm not the court.
All right. I think I have enough. No further questions.
Okay, Mr. Cohen?
Very brief redirect. Supervisor Rebikowski, with other properties, has LNI received emergency motions and
Objection. Relevance.
Agreed.
Mr.
Mr. Cohen,
Mr. Levy asks, basically, Supervisor Rebikowski, how is it that you're telling Ms. Spencer to file this court order for a TRO It's
The same
the
day as
offer
the
of proof
demolition.
would be, the offer of proof would be, it's what L&I does with other properties and has done for, I don't know, hundreds of other properties in similar
What?
situations.
All right, so
What do
stop.
they do?
Everybody
So-
stop. So Mr. Bukowski, is it standard practice to offer that information in these circumstances?
Yes.
Okay,
And
regardless. of
Even when
whether-
you only have a couple of hours before the demolition?
He said yes.
But
He
what
said
if the
yes. I mean, you
demolition's
can find it credible or incredible or incredulous, but you asked him a question, he answered it. That's the answer.
So just to come back, you don't know when that place was demolished, do you, Mr. Rybakowski?
I know it was placed to bid on the 18th.
The bid.
Okay, so he's already answered all of it. And he answered that he did
Yes?
not know. He
All
answered
right.
that he did not know.
Okay.
Okay, Mr. Cohen, quick redirect.
That was all the redirect I had,
Okay,
but thank you.
is that all of your evidence?
Just to note for the record, the city's exhibits packet for exhibits C26 through C30. I'm not going to belabor the point. Those are deeds. The first is to this property at 415 North 60th, and the other 4 deeds are those January 17th, 2024 deeds conveying 4 properties into trusts that occurred after the demolition had started. And with that, the city would move its exhibits packet into evidence.
So moved.
It's whole exhibit package, right?
Yes.
Yes, unless there's an objection.
No.
Okay, so Mr. Levy, any closing remarks?
Yeah. This shouldn't happen to anybody. The idea that a place is unsafe, I understand, everyone understands what happens with L&I, and everyone remembers the horrible tragedy at the Salvation Army building on Market Street. It can be just horrible when a building collapses. Lives can certainly be lost. This was, on the other hand, a one-story building which was vacant in the middle of winter, or in the beginning of winter. There were no people in front of it, no people in back of it, no people to the sides of it. Obviously, the first thing we have a problem with is the fact that the city was aware of addresses in Wynwood. They're aware of the address we have listed for our business at 401 63rd Street. And instead of basically contacting them officially there, they posted a notice on the building and made a phone call, supposedly to Miss Spencer at some date. We don't know how much time that Mrs. Spencer was initially told by in writing, you've got until the 28th of December to do something about this place, or we're coming in.
That I'm going to object on the basis of facts, not in evidence. The 18th was the
Well, this is
email
the
saying,
closing argument.
yeah, okay.
Go ahead, Mr.
I'm
Levy.
sorry, what did I get wrong, Jeff?
The 18th was the email to Ms. Spencer saying this building is coming down immediately. The 19th was when the notice was sent that you're saying at the December 28th, take action to remedy language.
But the notice exists, so
Yes.
go on, Mr. Levy.
So the idea is the city changed its mind on a basis we don't know because Mr. Rybakowski wasn't there. And the city decided that now we take it all back. We want it down now. And then they said, you do have, I wasn't there for the conversation. I didn't hear it, but you do have a remedy to this. You can get a temporary restraining order, but again, we can't tell you how many minutes from now you're going to have to get it in order for it to be effective. The whole thing comes down to this. If you're going to take someone's property from them in the United States under our Fifth Amendment, it's got to be through due process. If you're going to take someone's property down through due process, you're going to have to at least send a process server with a pack of stuff from Philadelphia, Mr. Cohen's whole, exhibit pack, if you like. And essentially on the front of it says, get this to a lawyer immediately. This is serious. You're about to lose your house. They didn't get that. They got stuff by regular mail. And essentially for urgency per sake, there was a sticker on the house, which was vacant. And she got an email and a first-class letter. I don't think that satisfies due process. Furthermore, I I don't really know whether it's appropriate for a city official to tell them, okay, you can avoid this by getting a restraining order. The man basically didn't make any foundation as to what his legal advice was based on. But we do know this, in writing, an 80-year-old woman got a notice, a written notice that says, you've got until the 28th of December to remedy this. And sure, you can say, well, I called backsies, or I had my fingers crossed, or we thought it over and we don't think it's a good idea to do that anymore. But Mr. Rybakowski wasn't even there to give us the benefit of his experience or appraisal. He didn't see it himself. He sent the place out for bids, and all these people do is make an honest living by ripping places down. They had no interest in saving it like they were supposed to be done on the 28th. I think, first of all the bills for remediation, whether it's for demolition or anything, I don't think the city deserves them. Then I honestly think we need a chance to determine the value of anything in there and anything the property was worth before they ripped it down, so we can restore.
Well, that I would actually object to. That's going beyond the
Okay.
four corners of the
I'll
petition for
end it
appeal.
there.
And also beyond the scope of the tax review board.
Yeah.
Okay, I'll end it there.
That's a different forum.
We
All right.
thank the board.
Thank you, Mr. Cohen.
Thank you, members of the board. The timeline in this is pretty simple and not really contested. Ms. Spencer says she received a phone call on December 16th. She then received a phone call from 2 days later from Supervisor Rybakowski on the 18th. She received an email from Supervisor Rybakowski to which she responded, and they had a brief back and forth. And she was also given by first-class mail and certified mail an imminently dangerous notice that I'm actually glad that Mr. Levy brought up due process, because that imminently dangerous notice was the opportunity to exercise due process. The city pointed out in that notice where it said you have the right to appeal. That right to appeal is statutory, and it would go to the Board of Building Standards. And yes, in this case, the city exercised its prerogative in an emergency situation to do a demolition immediately, but that still provides due process through post-deprivation hearing. And that's the key here. By failing to appeal to the Board of Building Standards, Ms. Spencer failed to exhaust her administrative remedy for a post-deprivation hearing. The Board of Building Standards is comprised of building experts, code officials, structural experts. They're the appropriate board to which to bring this argument of, was the building sound? Was the building unstable? Who is right? By failing to appeal to the Board of Building Standards, it essentially became the city is right by default because of the failure to exhaust. That said, I think the city tried here before this board to provide sufficient evidence to show there was an emergent condition, there was a leaning wall, bricks fallen on the sidewalk, a collapsed part of the roof, and frankly, a boiler that had asbestos installation, as we later found. All of this next to a property that had a playground, and for all that anyone knew at that time, could endanger the people who would use that playground. So that's what the city knew. That's what the city used to base its emergency decision, which it notified Ms. Spencer of in at least 3 different ways. So when we're talking about due process, let's keep in mind the city did its utmost to tell Ms. Spencer this is what's going to happen. You do have the opportunity to file a TRO action, and that's just based on Supervisor Rybakowski's previous experience telling other people you can file a TRO action, something he participates in fairly regularly. That didn't happen here. There was no TRO, there was no appeal to BBS, and the city moved forward with remediation, including asbestos monitoring and removal for this property to render it safe. Statutorily, that means that the city is entitled to recoup the amounts of these invoices. To be perfectly honest, it would not cause me to lose any sleep if the administrative fee were abated or just done away with. But the principal amounts that were paid to the city's contractors should be recouped, because otherwise this falls on the taxpayer. So that's what the city is seeking today, that we uphold the principles of these bills, and that essentially the city be allowed to take emergency action where it deems it necessary. And thank you very much, members of the board.
Thank you.
Oh, sorry, as one final thing that I almost forgot. The two appeals for the asbestos removal and asbestos monitoring bills are untimely. And the city fleshed out that argument in its position statement, but just to point out that they're untimely, and Ms. Spencer had the opportunity today to explain why they were untimely, but she didn't do so. So thank you.
Thank you. All right, the board is going to step back for a few minutes to a breakout room. Everybody just stay where you are. Milton?
So just so you know, Mr. Levy, about 20 minutes before this session started, all of the 15th floor at OPB lost internet access. So I was freaking out a little bit and trying to like arrange, okay, how am I going to go to some other building that has internet access to be able to, attend the Zoom hearing? So it's just lucky that access was restored before the session began. The modern conveniences really do sort of have a hold on us, don't they?
Thank you.
Okay, we are back on the record. We had a brief conversation, and it's the decision of the board that, based on the number of documents involved, the amount of testimony involved, we are going to take this matter under advisement so that we have an opportunity to really dig through everything and have a serious discussion on everything that's been presented to us, both from petitioner and from the city. We're going to leave the record open though, Mr. Levy. I don't know if your client has any photos or documents that you would like to provide in addition to everything that Mr. Cohen has provided.
No offense, I would object to anything being added after the hearing has ended.
Well, we're gonna leave the record open because if there are any, Mr. Levy, you're on mute. We cannot hear you. And we would, of course, offer you the same opportunity, Mr. Cohen.
You don't know how lucky you are to not hear me.
No, we're fine. But we're gonna wrap this up.
I sent Mr. Cohen a package of exhibits that I wanted to use today. But
Wait,
most by email with my response, the same day I sent the response.
sorry, I received your response to the city's petition. I didn't receive any exhibits.
Did you send it to the OAR office too? I don't
I
know.
think so. If not, it's okay. I'll get them in the next 24 hours.
All right, resend them. And Mr. Cohen, if you
Okay.
have any response to them in writing, that would be fine too. We're gonna leave the record open for like 2
Awfully close to
weeks.
yours,
All
Jeff.
right, we're gonna leave the record open for 15 days so that
Thanks.
Mr. Levy, send us your exhibit packet. Mr. Cohen, you can respond.
Mr.
In any
Cohen,
way.
could you please send it to myself also, so I can actually put it in the record?
Yes, it needs to go to the Tax Review Board office.
Well, Mr. Oates, did you receive the city's exhibits packet? and
Yes, I
position
did.
Statement earlier? Okay.
Yes, I did.
Yeah, that because that would.
I
that
got
know. Okay, so
Okay.
that's, all right, so we're leaving the record open for 15 days. And then we will, as I said, as a board, go through all the material, the testimony, the evidence, and then we will let you know when we have a decision to announce.
We thank you for your kind attention.
Thank you kindly.
Thank you.
Thank
So,
Thank you, Mr. Levy.
we'll be in
Thank
touch.
you.
Thank you, Mr. Levy.
Thank
And then we're just gonna move on to the one last matter
Oh.
we have on our docket. So, Mr. Levy, you're excused if you and your clients.
I was about to say, we have another one?
We have
Brandon
another one.
Greer.
No, we
Thank
have
you.
another one.
Thank you.
Which is listed as case number 2 on our
Have a great
docket.
weekend.
Take care.
You as well.
you.
3142 North Taylor Street. Last 4 digits of the docket are, oh, goodness me, hold on.
Is it R6LHLQ?
Yeah, LHLQ, the last 4
Oh,
digits.
sorry. Yes,
Yeah.
LHLQ.
And Mr. Greer, is not in the office, correct, Mr. Oates?
Correct.
Is not in the office, is not in our Zoom waiting room. We have not heard from him. Therefore, the decision of the board, as I recommended, is going to be to deny this for failure to appear. Can I get concurrence from the board members?
John O'Connor, I concur.
George Matthews, I concur.
Paula Weiss, I concur. So this matter is denied for failure to appear. I believe that concludes our docket for today.
Yes, it does. Thank you very much, members of the board.
Thank you all. Take care.
Thank
Have a
you,
good
Lashika
holiday
and Tom.
Great holiday weekend.
Take care.
You're welcome.
Bye-bye.
Have a good one.
Thank
Everyone
you.
have a nice weekend.
Take care,
Take
everybody.
care.
Bye.
Wonder if the Phillies are winning.
They're not, it's no score.
All right, well, it's better than Luke being behind.
Don't even say it.
Take care.
Have a good one.
You too. Bye. Julia's texting me. Kate's texting me. I mean, I don't know if people understand I'm working. You know, can you get a hold of them? If Kate's saying, do you want to